I'd like to answer that in two parts, generally and specifically. Generally, I would answer that every adversary proceeding that is filed, I read within 24 hours of its filing. I read every motion well before the hearing of that motion. The purpose of my telling you that is that this is your time to persuade me. And it's the time that impressions are formed. For example, if you draft a 523 complaint and you allege violation of 523A2A, A4, and A6, it makes me wonder which section you're proceeding under, because one set of facts can't satisfy multiple 523 sections. And similarly, if you're pleading under 727A and you have 5 counts, 4 of those are probably not going to work. And then specifically, what you want to achieve by well-pled pleadings is to avoid a motion to dismiss. So your pleading has to be specific enough and fact-intensive enough to pass the Twombly and Iqbal test. So let's give an example of that. Assume your pleading is a 547 preference action. Don't just allege the 5 elements, but with respect to before the 90 days, name the date. Don't refer to it as the transfer unless you tell us exactly what the form of the transfer was. That's how you integrate your facts into the pleading. So we want to avoid a motion to dismiss with specificity. Another technique that is useful in drafting pleadings is the use of headings. For example, parties, jurisdiction, facts. That compartmentalizes the pleading and makes it simple to follow. Lastly, when we're using defined terms or people, don't use initials. For example, if you're referring to the Fifth Third Bank, try not to use FTB, because the reader will say, what's the FTB again? Use common terms like bank, lender, creditor, borrower. The prayer for relief is generally an understated but a significant part of your pleading. I've seen it done several ways, and I'll recommend the best way is have in your wherefore clause very specific requests for remedies. For example, the relief requested may be to foreclose, 1. Number 2, waive the 14-day period of Rule 4001. And I've seen pleadings where the motion, one of the headings in the motion is requested relief. If you do that and then have the wherefore provision at the end, make sure that they coincide, because if they don't, it causes issues at the back end after the hearing. Then I've also seen it where the pleading suggests relief in the middle of the motion, and then the wherefore provision says, grant all relief requested in this motion. And we try to avoid that. I think that's the least likely to be helpful. For example, on a sale motion, you want to sell the property, file a report of the closing and the disposition of all proceeds. You can list, if you want, the steps of relief that you request. Foremost, and I think most important, proofread your pleading, preferably by someone who hasn't drafted the pleading. Number 2, use short sentences. Number 3, let me give you some words to avoid: hereinafter, wherefore, the aforementioned, on or about. On or about is probably my favorite. If you have a document, it's on that day. And the undersigned. So you could avoid those words plus several others in your proofreading. your pleading will be enhanced. Number 3, number the pages. Number 4, if you're referring to or incorporating by reference another document, state its docket entry number, the page, and paragraph. The Fifth Amendment requires due process, and by that, the Constitution means that you're aware of actions being taken against you so that you can appear and defend yourself. It's important that service be made properly so that a default judgment is not reversed after entry of the default. With respect to service, more service is better than less service. If you're filing a lift-stay motion with respect to foreclosure, name and serve both the note holder and the servicer. How to serve is found at Rule 7004. Be sure to look at 7004H, and that will help you how to serve and who to serve. First, look at the court's website. Hearing dates are noted for each judge. Call the courtroom deputy for that judge. Recite to them basically what you want or what the facts are, and ask them, may I have an expedited hearing? You'll get an answer or response the same day. The courtroom deputies are there to help you, and they will.
Well, once your matter has been set for hearing, the first thing you should do is reach out to your opposing counsel to see if there's any room for settlement. Some may find that odd, but in bankruptcy court, settlement should always be an option. There's limited resources, there's limited funds, so let's first find out, is there any room for settlement before we start expending lots of time and effort when settlement is possible. Now, the other thing that you want to do is also to communicate with the court. If you've spoken to your opposing counsel and you all have decided that you'd like a continuance of your hearing date to explore settlement, just contact the courtroom deputies and let them know. The courtroom deputies are there to help you, and they're glad to take that information and provide any other general information, no legal advice, that you might have questions about. And the other thing that you should avoid doing once your matter has been set for court is filing new or additional pleadings the night before the hearing. Your opposing counsel and the court need time to review whatever pleadings have been filed. And it may be that your opposing counsel no longer has any opposition with what additional information you filed, but they need an opportunity to review that, consult with their client if necessary. Likewise, if it's an objection to confirmation or an objection to a motion before the Chapter 13 trustee, again, that information may change their position and they may no longer have an objection, but they need an opportunity to review that. So when preparing for a hearing, if you're going to be presenting evidence, you need to make sure that you have the right number of exhibit binders presented to the court in advance of the hearing. You need a copy of the exhibits for the judge and also a copy for the law clerk. The other thing to consider when putting your exhibits together is what order are you going to be asking the witness about these different exhibits. Therefore, you can avoid the witness and the judge having to flip from Exhibit 1 to the back of the book to Exhibit 20, back to Exhibit 2, and things of that. I realize there'll be some flipping around, but let's try to, think about what order we're going to present the evidence so that it flows easier with the witness and the judge reviewing the exhibits as they appear in the exhibit binder. So you should outline your argument before you come to court. So as you prepare for the hearing prior to the day before in your office, you should think about what are the arguments that you want to make. You always want to start with your best argument. You may not get to your other arguments, so you always want to start with what your best argument is. If it's a case involving payments missing to the trustee or to a creditor, certainly if you have money, you should start with that. There's money here, Judge, and that would help. You want to avoid outlining your argument prior to stepping up to the podium. That includes the virtual podium. You want to already have your thoughts together, know what arguments you need to make, and in what order those arguments should be made. The other thing you want to do is avoid testifying at the podium. If there are additional facts or law that you want the court and your opposing counsel to be aware of, you should present that in writing. And if it's something that's come up at the last minute, then it may be that you need to request a continuance so that the court and your opposing counsel have an opportunity to review these additional facts or law that you're going to present in writing so that everyone is aware of what they are and can have an opportunity to review them. And as you prepare for a hearing, always be mindful of your duty to confer. Local Rule 2093B has a duty to confer generally. You should contact your opposing counsel. You should see, is there some opportunity for settlement, or is there some additional information or documents that need to be exchanged between the parties prior to the hearing. Also, Local Rule 4001-1E has a duty to confer with respect to motions for relief from stay. Therefore, debtor's counsel, if your client is interested in entering into a stipulation or some other payment arrangements on a motion for relief from stay, you should contact counsel ahead of time, not at the podium, about what terms would be acceptable for a stipulation. And on the same side, counsel for the creditors, you should get back to debtor's counsel in advance to let them know what your client is willing to accept for a stipulation, if there's a down payment requirement or whatever other requirements they may have, so that they have that information and can go back to their client and determine if a settlement through a stipulation is going to be possible. And then finally, Rule 7016C is a duty to confer with respect to adversary proceedings, and it requires that conference take place at least 14 days prior to the trial setting. Again, we're in bankruptcy court. There are limited resources, limited amount of dollars to go out to creditors. If there is some room for settlement, we should always explore that opportunity early on in the case.
Counsel's obligation is to present evidence. What is evidence? Evidence is facts that demonstrate satisfaction of the grounds for relief. It is a fact that your client filed a bankruptcy case on March 1st, 2021. It is not a fact that your client is insolvent. Instead, that is something where you need to show facts to demonstrate that the court can reach the conclusion of insolvency. Consider before every hearing or trial, do you need evidence? Is there anything you have to prove? If there's no disputes between your client and the adversary about facts, then you can stipulate. In order to stipulate, you need to agree with the other side that you do in fact stipulate. You might need to call the other side. You might need to meet with the other side. You will need to talk with them and determine what you can stipulate about, including the wording. If you're taking a matter to trial, then your trial scheduling order should tell you the timeline for agreeing to a stipulation and the timeline for filing that with the court. If you're doing simply a hearing, perhaps on objections to exemptions or on a motion to sell, the court's preference would be that you do a written stipulation of facts, which can be filed a relatively short time before the hearing. If you have an extremely simple matter, then it's amenable to have one counsel stand up and say that the parties have stipulated to the following facts. What we do not want to have happen is that a party announces that there's a stipulation when nothing is, in fact, stipulated. Again, plan ahead. You need to put something together, somewhere between a Post-it and a spreadsheet, that sets out first the facts you need to prove. Second, what will or will not show the fact, a document, a photo, client testimony, a pleading in the record, or something else, and how you will get that fact into evidence. Consider what is not evidence, what you say in a pleading on behalf of your client, what someone else says in a pleading on behalf of their client, and what an attorney says at the podium. It doesn't matter how long you or any other counsel talk at the podium, that's still not evidence. Think about a preference matter. It could be consumer, it could be commercial. If you're proving it up on behalf of the debtor, the first thing you need to show under 547B is a transfer. So, what will show a transfer to a creditor? Is it a check? Is it a receipt? A deed of trust? A bill of sale? A Facebook post? Testimony? Or something else? Once you identify that item, how are you going to present it to the court? Are you going to provide a certified copy? Are you going to have a witness authenticate the document? Are you going to put up a copy of a website on the Elmo or on a laptop? And then, how will you authenticate the document? You should be able to identify these items for each and every fact. If you're going to use a witness to help you get a document or other information into evidence, again, plan ahead. Unless this is your own client, this person may not come to court of their own accord, in which case you will need to subpoena them. Look at the applicable rules of federal civil procedure and federal bankruptcy procedure in order to know how to do this. You cannot plan too far in advance for this. Parties have conflicts, parties have other scheduled items, and you are responsible for making sure your witnesses are present. I know that attorneys hate to bother their clients, but realize it is important that your client be invested and involved in these proceedings. Do not figure out what evidence you need in the courtroom. You need to have planned this ahead. Court is your chance to make your argument. You don't want the court to hear you negotiating about whether a document is admissible. Spend the time in the courtroom pleading your client's case and getting the high points across to the judge. Sometimes in these matters, opposing counsel will be uncooperative. Maybe they don't respond to your emails or your calls. Maybe they don't want to participate in preparation. You may not be able to make opposing counsel participate without court involvement, but again, that's why it's important to start these processes early so that you have a chance to bring matters before the court. However, failure to reach an agreement with opposing counsel does not excuse not being prepared. It may be you have to prepare on your own. If that's the case, you can do this. You know how. Come to court ready to go. Plan ahead. You want to be the party who has their evidence ready to go and organized. Your chances of prevailing are much greater if you have actual evidence in the record. Foundation, judicial notice, self-authentication, and objections. To be really honest, there's a lot more things to focus on, but they've only given me a little bit of time because I have to let Judge Shermer talk too. Foundation is the basis for and process to demonstrate to a judge that evidence actually is what its proponent says it is. For example, that a deed of trust accurately describes property, or was actually recorded, or that an expert witness actually is, in fact, an expert. How do you know how to lay a foundation? Happily, we have books that deal with that. My favorite is by Edward M. Winklereid. We fondly call him Winky. Evidentiary Foundations. I have the second edition and the fifth, but you can choose which one you want to work with. The publisher's up to the 11th now, and if you don't want to spend the money for a hardcover copy, which runs about $200, it's available in the library upstairs or through a lot of electronic databases. These books tell you exactly what questions to ask in order to lay a proper foundation. You don't have to figure this out. There are resources available to you. Judicial notice is described under Rule 201 of the Federal Rules of Evidence. And yes, there are federal rules, and in fact, they're in a lot of bankruptcy code books. I use this book because the rules of evidence are right in there. Notwithstanding the old joke about bankruptcy being a place where we don't worry about evidence, we really do have to have it. A request for judicial notice may be made with regard to a fact generally known in the court's jurisdiction, or that can accurately and readily be determined from sources whose accuracy may not be questioned. For example, a court can take judicial notice of a petition or discharge date that's noted on a court's docket in a bankruptcy case. A court can take judicial notice that August 3rd, 2020 was a Monday, that Bismarck is the capital of North Dakota, that a creditor withdrew its objection to exemptions on May 14th, 2020. But a court cannot take judicial notice of a statement by a party in a pleading, for example, that the debtor is insolvent, that a house is worth $162,000, or that apples do not grow well in Iowa. Judicial notice can be a useful tool, but you must ask the court to take that judicial notice and provide the court with proof of the source if needed. Self-authenticating evidence is evidence that doesn't require anything extrinsic to make it admissible. Self-authenticating items are covered by Federal Rule of Evidence 902. Examples include signed and certified public documents, certified copies of public records, public authorities' publications, for example, the Internal Revenue Code, printed newspapers and periodicals, trade inscriptions, and certified domestic records of a regularly conducted business activity. If you're going to have a self-authenticating item, then you need to be sure that you bring enough copies of that item for everyone to review, just as Judge Surratt States has already told you. If you're working with something like a book or a magazine, bring the original and appropriate photocopies. If you're working with a trade inscription, perhaps a serial number from a tractor, be prepared to prove up what the actual inscription is. Maybe bring the plate from the tractor, maybe have a witness who testifies, and then deal with those issues. Be prepared to deal with self-authentication. It can save you a lot of work, but only if you've laid the ground for it. For example, if you wish to use a self-authenticating deed of trust, then you need to have a certified copy of that document. Just because an item isn't subject to judicial notice and isn't self-authenticating doesn't mean you can't get it into evidence. It just means you're going to have to do it the old school way, by a witness or by a stipulation. Again, plan ahead so that you have the appropriate people to make this happen. If you wish to make an objection to evidence, do it right away. This is not the Depp Heard trial. You can't object later on. It's okay to object first and then to gather yourself to enunciate the basis for the objection. This isn't jeopardy. You have more than 10 seconds to explain to the court why the objection is appropriate. Once you're ready, state the grounds for your objection specifically. lack of foundation. The question calls for hearsay. The question calls for an improper opinion by a purported expert witness. Or, I object because the document has been insufficiently authenticated. And then, be prepared to substantiate your objection. Ms. Smith is not a licensed Missouri appraiser. Dr. Ames testified she never examined the patient. Mr. Zafar already stated he was not at the director's meeting and has no personal knowledge about what occurred there. You may be able to anticipate some objections. In that case, it's all right to write them down and be prepared, but you need to make your objection of record. Remember, evidence not objected to is more likely to be admitted. Even after your hearing or trial is over, it ain't over. In order to put an order together, you need to know what's being ordered. In some cases, it's very simple. The objection to exemptions has been granted, and the debtor is not entitled to claim a head of household objection in the motor vehicle. But many times it's more complicated. That's what I'm focusing on today. First, if you prevail, you generally get to write the order. Rejoice! You get first crack at it. You can make sure it includes everything that you want to have in it. But how do you do that? We understand that a trial and a hearing is a very busy proceeding. You have a lot going on. You have papers, you have clients, you have opposing counsel. The courtroom's busy. Maybe you didn't hear everything the judge said in the ruling. That's all right. You can request that the court do a DAR, or digital audio recording of the hearing. DARs are available to you online for free, so you can listen to the hearing at no cost. Note, you can also get a recording of your own to keep or a transcript, but the time and costs of that can be somewhat more. So DAR may be a good alternative to hear what's been ordered and what needs to be addressed. Your order needs to do two things. First, address what was in the motion or the complaint, and second, address what was ordered at hearing. Please make sure that you address everything in your complaint or in your motion. If you asked for abandonment in your motion, make sure you address that in your order. Looking at this the other way, though, if you didn't ask for abandonment in your motion, it doesn't belong in your order unless you specifically requested it at hearing. This is on you. Check your motion before the hearing to make sure you address all requested relief. But let me be clear. I've polled my colleagues, and none of us intend to give you relief you didn't plead for in your motion. Our suggestion is to do your first draft of an order when you're drafting your motion, to make sure that the wherefore paragraph in a motion or the conclusion in a complaint matches up to the proposed order. The next most important thing that you need to do is set out what needs to be in the order to grant complete relief. In some cases, you may find it easier to provide that, quote, for the reasons stated on the record, the motion is granted, but we recommend that you explain. For the reasons stated in the record, the motion is granted, and that relief from the automatic stay is granted as to the property located at 1234 Smith Street, and for such purposes the automatic stay of 11 U.S.C. Section 362 is terminated to permit the movant to foreclose on the property. Period. This gives you a more usable document. Please actually submit the order and do so relatively timely. My colleagues and I have different time frames for submitting orders, but all of us have denied relief requested in a motion because no order was ever submitted. If the court is calling you for an order, be assured we will not be drafting that order for you. So in order to get the relief your client wants, make sure you send that in. And if you have any questions, reach out to the staff. Talk to the judge's courtroom deputy. We may be able to provide you with forms or direct you to other cases where similar relief has been requested so that you're not starting from scratch. We don't want to make this difficult for you, but we ask for your help and cooperation so that we can continue moving through our docket and dealing with your matters.
As you heard multiple times, we have benchmarks that we hope that you will be able to meet, and we know that this information will help you get there. You heard plenty of times during the presentation that the clerk's office is available to assist you. I know that many of you have used our services, but I encourage you to not be shy. Please take a moment to contact the clerk's office. We will do everything we can to give you a prompt response. You can also go to the court's website. We have so much information there. We publish hearing information dates, we have filing informations, we have calendars, our rules, our procedures, and so much more is available on our court's website.